Hello and welcome to Connected with Latham, where we discuss ideas, legal developments and business trends shaping the global economy. I'm Rob Moulton, a partner in Latham & Watkins' London office. In this episode, part of a 10-part series complementing our 10 key focus areas for UK regulated firms in 2024 report, we discuss regulatory divergence. I'm joined by my colleagues, partner Nicola Higgs from the London office and Markus Krüger from the Frankfurt office. Nicola, Markus, welcome to the podcast.
Thanks, Rob. It's really great to be here with you both.
Thanks, Rob. Thanks for having us and glad to join you.
So, what level of regulatory divergence have we seen so far? And have we seen any surprises? Nicola?
Thanks, Rob. So I'll pick this up from the UK perspective so far, and it leads back to December 2022 when the UK first made clear via the announcement of the Edinburgh reforms its intention to chart its own course in rulemaking in the financial services sector rather than prioritise seeking out strategic equivalence with EU rules. The UK has since been undertaking a very significant exercise to repeal all retained EU legislation relevant to financial services and then restate all of those measures across UK law and regulation. So that repeal and restatement exercise is a mix between substantive policy change and then just simply changing some of the technical nature of the rules. The key driver behind that move is to ensure that all of the regulation inherited from the EU is written out using UK terminology and allows for a UK model of regulation by making sure that those rules sit in the regulator's rules rather than in the legislation itself. So consequently, while we're repealing every piece of EU regulation, and that sounds very dramatic in theory, this is more of a technical legal exercise than a total bonfire of all EU regulation. Some of those areas of diversion so far have been quite predictable. So the UK government is naturally going to prioritise its competitiveness by introducing extensive reforms to our listing regime, making sure that people come and list their companies on the UK London Stock Exchange and we re-energise our capital markets. And the other areas of divergence that we've seen in the UK have been focused on fixing areas of legacy EU law, which have proved a little bit of a pain point for us practitioners and the firms we advise in the UK financial services sector. And that's included parts of MiFID II, our securitisation rules, our Solvency II rules, PRIPS-KID, and other types of consumer credit regulation. So just a couple of examples from my end in that regard would be removing aspects of the regulation that the UK has clearly wanted to change for some time. Things like the banker's bonus cap was very unpopular. The share trading obligation was incredibly problematic. The disclosures under the PRIPS regime didn't quite work and were sometimes misleading. And, in the case of the latter, we're planning to completely overhaul that with a new UK retail disclosure regime during 2024. But there's also been some quite striking developments in the UK policy on rule changing. And one of those related to the decision to scrap the compulsory research unbundling rule. That was very surprising given it was originally an FCA introduction to the European regime in MiFID. So, of course, divergence is occurring not only because the UK is reviewing and changing its own rules post its exit from the EU, but also because there have been changes at EU level, which we're no longer part of in the UK. So, Markus, perhaps it's a good time for you to pick up what you're seeing in that context.
Thanks, Nicola. And I know that the UK is much more focused on the divergence issue than the EU is. And correct me if I'm wrong, but definition of divergence seems to be one of the UK diverging from the European rules and not the other way around. So Europe, I think rightly or wrongly, whichever way you choose, and I think some German and European firms are looking enviously at what's happening in the UK right now. But Europe does not see the UK as the guiding path to which it may cling or from which it may diverge. That said, in a broader sense, I see 4 fields of divergence from an EU perspective. First, there are the rule changes that the UK implements and will implement, as you just described, Nicola. Second, and you already mentioned that as well, is the divergence by way of development of the European rules going forward from the status quo at Brexit. Just by way of example, I think we're expecting major changes as regards AIFMD, MiFID II, and scope of benchmarks regulation, which will not be implemented in the UK. Likewise, there's PSD3 PSR, which will result in divergence, and the same is true for Solvency II reform. Similarly, there are certain areas that are or will be regulated either on a European or national level. That is particular with regard to new technologies, crypto assets, where we now have MiCA on a European level, but also regulation on a national level. And as a subpoint maybe to this, the implementation of all those new and revised European rules may also differ, obviously, from country to country in the EU, so it's not all centralized. Third aspect is the divergence by way of administrative practice in second and third level rulemaking, obviously. We all know that the European supervisors tend to interpret their competencies broadly, and they will continue to issue regulatory guidance on specific subjects. While previously the UK authorities would keep their own guidance in that framework, they're now free to provide guidance based on their own view of market developments. And let me just add, as a German lawyer, I'm a bit sad to see the FCA guidance go and not be relevant for Europe anymore, because they had more comprehensive guidance than many of the national regulators in the European Union. And fourth, I think there will be divergence, and that is one that is often overlooked, that affects the financial sector, that is really non-financial sector specific regulation. We've already seen GDPR and the impact that it has on anybody in the financial sector. And it stands to be seen what specific impact the AI Act that was just passed or the Digital Services Act will have on the financial sector. But to me, it seems clear that the UK will not implement carbon copies of these acts.
Markus, that's really interesting. I mean, it isn't always clear from London that practitioners in Frankfurt might miss their ability to refer to FCA guidance on topics. We don't always love looking at it over here. So the irony won't be lost on some of our listeners that they're not having that guidance.
And just anecdotally, I mean, the EU regulators are picking up on guidance note and they're issuing more and more, and same as BaFin. But when Brexit happened and we pointed out to BaFin that some of our clients are looking at BaFin taking the lead now in issuing guidance on the interpretation of European rules, with the FCA basically being out of the game, BaFin seemed very surprised. But it shows you that, previously people were looking at where there was no European guidance and what the FCA would say to specific European rules. And that is gone.
And just on that point, do you think we will see BaFin issuing BaFin guidance more regularly going forward? Or will we see the BaFin trying to work through and influence ESMA to give guidance in order to fill some of these gaps?
That's a good question. I think there are some people at BaFin that will push for more guidance, and we have in fact seen more guidance. They've restructured the regulator in order to have more sector-specific competencies in certain areas. So I would expect there's more guidance in that regard. But they have been reluctant, for example, publish their guidance always in English as well. And German guidance, as much as I like the German language, will not help anybody coming in from the outside very much.
And so, Nicola, do you think we're going to see the pace of divergence increase, or have we seen the burst immediately post-Brexit and we'll see less going forwards?
Thanks, Rob. It's a good question. And I think there's probably two drivers behind the answer from a UK perspective. So one of the goals of the UK will be to be seen to be strategically aligning itself globally rather than strategically aligning itself with the EU. And in that regard, not having to move as part of the EU pack makes it a little bit more nimble. It can do things with more of a quick pace, and it can introduce reform topics where it thinks it's the right thing to do to stay globally relevant and globally competitive more quickly than it could do previously. So on the one hand, it has the toolkit to move at a fairly quick pace now. But that being said, I think the pace of regulatory divergence is unlikely to see any new material topics evolving in 2024 at least. I think what we will see is more progress on the existing published reform agenda, because the regulators are just likely to be very well occupied with the task of reviewing that EU retained legislation and rewriting it into their rule books, rather than coming up with any new kind of policy making objectives over the course of the next year.
What do you think, Markus? Will we see more pace and more policy in 24 in Europe?
First, I fully agree with Nicola on the development in the UK. But obviously, and as I just stated, there will be regulatory developments in Europe which are quite far-reaching, such as MiFID reform, AFMD, PSD3, PSR, and obviously implementation then of other acts that are currently in the making that are not financial sector specific, as I said. But on the other hand, I think there's not only divergence, but there's convergence as well. We're looking at the implementation of Basel 3.1, Basel 4, whatever you want to call it, and that's been agreed on a macro level. And so there are general rules and a general framework that are agreed that will be implemented in the different jurisdictions. And implementation may differ. Yeah, we've all seen the excellent piece that our US colleagues did on the Basel implementation in the US, which they call gold plating. I've not quite grasped yet whether that is the case or not, but obviously it will differ in different countries. But the general rules are the same. And again, there's small divergence, like the timeline with the UK postponing implementation of Basel to, I think, July 2025 now, and the Europeans sticking to January 2025. So there's a delay maybe, but I wouldn't call that divergence. That's just a delayed convergence, if you so want. And similarly, there's other areas there on the macro level. There are multinational or supranational institutions and respective arrangements, such as in the case of anti-money laundering FATFA, and both Europe and the UK are part of that, so we'll implement the respective rules. And the same may be said of some of the rules and agreements that come out of G20 arrangements.
So where do we think the UK-EU relationship is at the moment? Is this a happy pair? Are we going to see more cooperation, Nicola?
I hope so. I mean, now that the dust has settled on the political posturing of the Brexit negotiations, I feel much more optimistic on the prospect of more express cooperation between the UK and the EU in future. So whilst I think it's fair to say that we as advisors are now being asked, what do the UK rules say, rather than how do the UK rules differ from the EU, I think the market has adjusted to the fact that there is, separation of policy making and thinking in that context. Just as Markus has outlined, really, we are seeing a real alignment in terms of the macro trends hitting the financial services sector and the way in which the UK and the EU go about bringing in regulatory regimes for those trends. So one of the main reform topics on the UK side in 2023 was retail investor protection through the form of the consumer duty. And we've seen the same trend in the EU in the context of the EU retail investment strategy. So it seems quite clear that the regulators are looking at some of each other's forward-looking policy and recognizing it's important for firms for them to introduce at least not conflicting agendas in that context. The ESG reform would be another good example where, there's very separate EU and UK regulatory frameworks being built. And those frameworks are being built at quite different paces and with some very noticeable differences in terms of, the level of detail and some of the focus areas. But they are capturing the same broad trends in terms of, who they want to regulate in the context of the ESG agenda around public company disclosures, fund labeling, and ESG ratings. So all of those forward-looking trends do point to the fact that the regulators are at least looking over their shoulders at what each other are doing. And so that leads me to think we'll start to see more express cooperation in future.
Is that how it looks from a European perspective, Markus?
I absolutely agree. I think the regulators are talking, which, is always a good thing. As long as people talk, there's a good chance that they'll come up with similar ideas, or at least agree that the other one has a bright idea that is worth considering. And in that context, we've all seen, and I think favorably seen, that the UK and the EU entered into a memorandum of understanding on regulatory cooperation in financial services in 2023. Now, that only establishes, or mainly establishes, a forum for the regulators to speak and exchange ideas and regulatory supervision matters. But it will likely increase the dialogue in relation to regulatory initiatives. So we'll not have a significant direct change in the relationship, but over time, one is hopeful that it will have an impact in terms of similar approaches to the same problems. And I think many of our clients, firms operating on cross-border basis, hope that this cooperation or discussion forum will result in a more coordinated approach and will help to mitigate the risk of regulatory divergence. Now, how far that will go, I don't know. I mean, personally, one would hope that this may even be advancing the idea of regulatory equivalence decisions that I know we as a group have talked about a whole lot for cross-border services being rendered, i.e. the acceptance of UK rules as equivalent to the EU rules, resulting in UK firms being permitted to render services in Europe. For now, that is just a hope, so we'll see what the future brings.
But it sounds as though that forum, Markus, at least indicates an end to the posturing that Nicola mentioned and the start of dialogue between the authorities?
I would hope so, and it's a counter signal to what we've previously experienced, where the signals by the European regulators were, if you are from the UK, you now need to be much more aware of the rules that we're making here, and you can't expect us to letting you continue the practice as previously, particularly not, in fields that we regulate. So if you want to practice here, we want to supervise you. And now with that forum, I think at least the ground is laid out for cooperation and basis to build on.
Well, I look forward to coming back to see how that forum goes in future years. And Markus, Nicola, thank you very much for joining me to discuss Divergence.
Thank you, Rob.
Thanks, Nicola and Rob. It's great to continue our discussion on this subject matter in a more public space.
And thank you for listening to this episode in our Connected with Latham podcast series. You can subscribe and listen to new and archived episodes of our podcasts on lw.com, Apple Podcasts, Google Podcasts, Spotify, or wherever else you get your podcasts. And if you'd like more information about the topics in this podcast, or to access our 10 key focus areas in 2024 report, or to read the Basel III note that our colleagues have written that Markus mentioned, then please visit the links located in the show description. And we hope you'll join us again next time.
This podcast is provided as a service of Latham & Watkins LLP. Listening to this podcast does not create an attorney-client relationship between you and Latham & Watkins LLP, and you should not send confidential information to Latham & Watkins LLP. While we make every effort to assure that the content of this podcast is accurate, comprehensive, and current, we do not warrant or guarantee any of those things. And you may not rely on this podcast as a substitute for legal research and/or consulting a qualified attorney. Listening to this podcast is not a substitute for engaging a lawyer to advise you on your individual needs. Should you require legal advice on the issues covered in this podcast, please consult a qualified attorney. Under New York's Code of Professional Responsibility, portions of this communication contain attorney advertising. Prior results do not guarantee a similar outcome. Results depend upon a variety of factors unique to each representation. Please direct all inquiries regarding the conduct of Latham & Watkins attorneys under the New York's disciplinary rules to Latham & Watkins LLP, 1271 Avenue of the Americas, New York, New York, 10020. Phone number 1-212-906-1200.